Hearing the appeal, the Queen on the application of Edwards and another against the Environment Agency and others.
Before you begin, Mr. Reedy, perhaps just for everybody's guidance, at 11 o'clock there will be an announcement from somewhere remote in this building which will call us to order, and we'll rise, of course, and observe the silence, and we'll be told when the 2 minutes are finished. Yes.
Good morning. I have the good fortune to lead Mr. Marici and Mr. Banner in this matter. My learned friend, Mr. David Wolfe, appears on behalf of the appellant, Lilian Pallikarapalos. Both parties, I think, have stuck with the names or the titles of the main proceedings, so I shall be referring to her as the appellant, even though strictly on this issue she isn't.
Yes.
And the Secretary of State is the respondent in the main proceedings.
Yeah.
This matter comes before the court by way of a reference from the single justice under your rules, Rule 53, Sub-Rule 1 and 2. Your rules are in relevant part at tab 20 of Bundle 2.
Yes.
I don't think we need to go through it.
Well, we've of course read your submissions and your further submissions, and we have the background very much in mind.
I'm grateful. You will have seen, therefore, that the appellant applied at an earlier stage of these proceedings for a protective costs order, and in a second bite at the cherry, applied also for there to be no order as to costs at the end of the proceedings. She did so on each occasion inter alia on the basis that such orders were required in order to avoid breaching European directives, and in particular the prohibitively expensive principle. Or the order for the application for the protective costs order was refused by the House, and the second bite at the cherry, the application for there to be no order, was also in effect refused by the House, which made the usual order that the costs follow the event. The central question on this reference is whether or not the appellant can resurrect, in effect, precisely the same point at the detailed assessment stage, with the related question whether costs officers have the power to permit her to do so.
Is it an estoppel question, or is it a res judicata question?
It's
the same
we've cast it could be either. We've cast it rather as a jurisdictional point. Do the costs officers have jurisdiction under the rules to apply, as it were, a broad, prohibitively expensive cap or reduction to the costs that they would otherwise, on a detailed assessment, assess to be reasonable?
Well, there are two ways of looking at that. One is absent a decision on the point by the House. If the House had made just simply an open-ended order, as it were, just an order for costs, whether there would be jurisdiction to apply, or indeed a requirement to apply the Aarhus Convention rule, or whether the position is altered by the fact that, as you say, there was a decision taken on the point after submissions had been made.
My Lord, we put it both ways. We say there has been a decision of the House, and in any event it would be inappropriate as a matter of jurisdiction for costs officers to take that sort of approach on a detailed assessment.
Well, isn't the logical order, or the more helpful order, to take those questions in reverse? So at least we know what the ordinary position would be, and then we ask whether it's excluded or prevented by the specific circumstance of what might be regarded as an issue estoppel or res judicata.
Well, of course, one can take the issues in that order.
That's a much wider question, and goes outside the facts of this case and would apply across the board.
Well, yes, which is why it's an issue of some importance.
Yes.
I was going to structure my submissions by reference, first of all, to the chronology, so that one sees how that arises. That will, to some extent, drift into the facts of the case and do it, as it were, in reverse order, but at least by way of background, you will then see it. And then I was proposing to take the rules and the jurisdictional issues later, and then come, obviously, at the end to
well, perhaps you should take it in the order which you planned, Mr. Reedy, but you'll appreciate that we're very interested in the point Lord Mance raises.
Oh, yes. The submission which is in effect made is that the principle that should be applied by the other side is that at the detailed assessment stage it would be permissible for costs officers in effect to reduce the costs that would otherwise be payable to nil or to some nominal amount, to £1. So in other words, a very significant reduction, not as it were linked to the usual exercise on reasonable assessments. The costs officers concluded in their decision, which you will have seen in the bundle, no doubt, they concluded that they would be entitled, as part of the detailed assessment, to make such an order on that basis. In effect, therefore, they've concluded that it would be appropriate for them to make an order which, in effect, removes from the appellant a cost risk knowingly undertaken by her after the PCO was refused, and require it, in effect, again, to be borne by the taxpayer. That is the consequence of the order which is sought. So far as the chronology is concerned, the proceedings themselves arise out of a decision by the Environment Agency to grant a conditional licence to a company, which was the interested party in the proceedings below, for the continued operation of a cement plant in Rugby, and specifically for a proposal to burn waste tires in place of conventional fuel in the kiln at the plant. The claim was originally brought by a legally aided person, Mr. Edwards. It was brought against the Environment Agency as the body issuing the licence, and also against the Secretary of State as the person responsible for transposing the relevant directives. The litigation started with some early skirmishes about whether or not Mr. Edwards was a person with a sufficient interest to bring the proceedings.
Do we need more than we get from Lord Hoffman's speech in the House of Lords? Because he does narrate the history.
My Lord, you probably don't. What we have done, because the reasoning is to some extent different as one goes up the court system, what we have done, I don't know if it's been handed up, on your desks you should find a short note from us entitled Edwards Palikaropoulos Summary of High Court, Court of Appeal and House of Lords Reasoning and Decisions.
Yeah. It looks like that, I think. Yes.
I mean, rather eccentrically, included in our bundle is the draft judgment of the House in the case rather than the final judgment.
Oh.
And it excludes paragraphs in my Lord and the Chair's speech and in Lord Hoffman's speech, which actually are referred to by paragraph number in the arguments. But it is rather bizarre to put in what was not the final copy.
Well, my Lord, I apologise for that. We will ensure that the correct version is in.
It's in the reports. I think we can find it. But
Yeah.
it is odd that we weren't provided with the version in the official reports.
My Lord, I apologise for that. We can rectify that. But you'll see the nature of the note is designed at least to provide a summary of the reasoning of the various courts on the substance of the matter, which obviously isn't a matter which we need to dwell on for this purpose. Procedurally, and so far as the costs position is concerned, the first thing to note perhaps is that on the 8th of February 2006, on day 3 of the 3-day hearing before the Court of Appeal, Mr. Edwards withdrew from the case in the circumstances that are described in tab 9, if you would, in the principal documents bundle, tab 9, pages 20 to 24.
Yes.
In particular, paragraphs 4 and 5 of that, which describe the circumstances in which he came to withdraw from the proceedings. I won't read them out, but perhaps my lords could cast an eye down those 2 paragraphs. Paragraphs 4 and 5.
Yes.
Mrs. Palikaropoulos was then added as an appellant. I understand that Mr. Edwards remained, but thereafter played no further part. And the appellant, as I will call her from now on, was not legally aided. And what the court did was to fix a cap for the purpose of the remainder of the Court of Appeal proceedings on her liability for costs at £2,000, as you see from paragraph 14 on page 23.
Paragraph 12, she's brought in. And
Yes.
Paragraph 14 is the costs point.
Yeah.
Yes.
She then launches proceedings by way of a petition to the House of Lords challenging the judgment of the Court of Appeal. And if you just track on in this bundle, at pages 25 to 26, you'll see that on the 26th of January of 2007, she sought agreement from the Environment Agency to a waiver of the security for costs requirement in the proceedings before the House of Lords. And she put them on notice that she would be applying, in the absence of consent, for a PCO, a protective costs order. And you will note from the penultimate paragraph of that letter on page 26, towards the end of it, that she relied upon the directive even at that early stage.
Yes.
That invitation was declined by both respondents, as you will see from pages 27 and 28. And that led her on the 5th of February 2007, see page 29, to apply to the House for orders that she be released from the security for costs requirement and a PCO. Again, I'm not going to track through all of this reasoning. It runs on to page 35. You will note in particular on page 32, on the last full paragraph on that page, the attitude that was being taken to the disclosure of the means of the appellant.
This is really the beginning of the argument that it should be assessed on an objective basis, isn't it?
It's part of it, yes. But she effectively declines to produce detail or evidence of her means, in effect. See the last full paragraph on page 32. Over on page 33, on the first full paragraph, you will note that at that stage, what was being said, see the final sentence of that first full paragraph, was that the advice of the lawyers to her would be that it would be unwise for someone like her not to withdraw from a case like this if a PCO is not granted. Now, in the event, as we know, that advice was not followed, and she did in fact proceed. And you will note on page 34 that there is a section which specifically raises and deals with the directive points. So the first 5 paragraphs on that page are squarely raising the points about the directive and prohibitively expensive. Finally, you will note on this letter on page 35, the second full paragraph on the page.
It's interesting in the middle of the page, therefore, above all, the problem with legal costs is the unknown exposure, the black hole of the other side's costs. Is it indicated in this letter on what basis she was proposing to fund or arrange for her own costs to be covered?
Well, no, that's not dealt with in this letter, although we do have some information on that, which I'll come to later, at least in terms of the scale of those costs.
One of the interesting questions is how far, I suppose, under the directive, a court would have to concern itself with that.
My lord, yes. Yes, and I'm sure at some point your lordship are going to be troubled with assertions that legal aid is required, for example, in relation to these sorts of cases as part of that.
Or I mean, I suppose one answer may be, well, you can probably find someone to do it on a conditional fee agreement, but if you can't, then presumably a court would have to consider the appropriateness of the level of costs being charged between solicitor and client.
Well, they may do, or they may have to consider other ways in which it could be funded or in which representation could be provided. But at the moment, at least, we're focusing on her application, which is that her liability for costs in the event of failure by her in the appeal should be capped. That's the essence of the PCO, and you'll see what position she's taken in relation to disclosure of her means there. You'll also see that she did, at least at this stage, propose as very much an alternative, see the second full paragraph on page 35, that if your lordships are otherwise minded or minded against her primary argument, then it might be appropriate to impose a £10,000 cap.
So that's a very guarded offer, as one can see. It was made without instructions.
Yes.
And just a suggestion.
Yes.
And that wasn't taken up by anybody, was it?
Well, that was a point that was made in response by the Treasury Solicitor, and it did harden to some extent, as we'll see in a moment.
Right.
But my Lord is right to point that out.
Sorry, I'm being a bit sad. Does this letter deal too with the security, which I think was 25,000? I've rather overlooked that. Where's that dealt with?
Last page, 35.
Yes.
Oh, yeah.
Yeah. And also in the next letter.
So where's the 25,000 actually come from?
I'm not sure, was that the standard amount?
That was I think that was a standard rule in the House of Lords, which we departed from here. Yes, it wasn't a fixed figure, and as you know, we don't have that anymore, but that's the history of it.
You'll see she returns to the issue of her means in the 9th of February letter at page 36, that in response to a letter from the Treasury Solicitor, which you'll see quoted at the outset of that letter, in effect saying, could you please provide information as to your means, and her position on not doing so, in effect, is then clarified thereafter. And you'll note at the bottom of that page that on the subject of the fees that she herself has incurred, that at that stage, by that stage alone, she claims she'd incurred in the region of £40,000 of her own money on funding her own legal costs. There were then responsive submissions from the defendants, starting on page 38. Two points perhaps to draw attention to in relation to that. First of all, under the applicant's resources on page 42, you will see the position taken in relation to the disclosure of her means. See in particular from the middle of the page under the title, the applicant's resources, those next two paragraphs.
Yes.
And you will see over the page that there is direct engagement on the issue of the directives.
Mr. Eady, a separate point, but what's the limit now in terms of available resources or whatever it is for legal aid? At what point do you cease to be eligible?
I will check the precise figure. I think it's 17. Can I check that? And
Yeah,
we'll give you chapter and verse on that.
Yeah.
The response to those submissions is at page 45. So So by this stage, you had full and detailed submissions from her, then you had a pretty detailed response, all directly grappling with the issues under the directive, under the disclosure of her resources and so on. And then on page 45 is, in effect, a reply. You'll see on the points that my Lord Hope raised with me, paragraph 2 on page 46. Where it's still a suggestion, but brackets not offered without instructions on the 10,000 point.
Yes.
And you'll see that there is then further engagement on the issue of the directive at paragraph 6. And that is then referred to again on the very last couple of lines of the letter. So that exchange of written submissions then leads to the first ruling of the House on the 22nd of March 2007, and you'll find that ruling at page 48 of this bundle. And you'll see in particular what is said in the final paragraph of that. Lordships proceed on the basis that the appeal raises an issue or issues of general importance. They're prepared to assume that absence of private interest may not always preclude the making of a special court cost order in such a case, but their Lordships do not accept that information about the applicant's means, about the identity and means of any who she represents, and about the position generally, in the absence of any special order, are or should be regarded as immaterial. Further, they do not consider that the suggested protective costs orders regarding costs appear proportionate on the information which is before them and in the light of the nature of the issues involved, and they do not consider that any case has been made for saying that the proposed appeal would be prohibitively expensive or that the directive would be breached without a special order. So you will see that that ruling is given addressing in terms the directive issues and arguments that have been raised in some detail in the correspondence, or more accurately in the written submissions, that had preceded the ruling. My submission is that that ruling was a carefully considered ruling following full argument on the issues.
Well, that ruling is not being challenged in these proceedings, obviously, in the sense that we're concerned now with the costs order that was made at the end of the case. Am I not right? I mean, there is a question as to whether, obviously, behind the scenes, as it were, whether the right decision was taken. But to an extent, that's water under the bridge, because the case proceeded, and we're faced now with an appeal against a decision by the cost judges, the case having got to them.
My Lord, yes. What we do say, however, is that this ruling is an essential part of the story leading up to that. Not least because if you're going to raise issues about things being prohibitively expensive, the natural and appropriate time, jumping ahead a bit, but the natural and appropriate time to raise that is at the early stage of the proceedings, at the early stage, in this case, of the appeal. That is the time at which these sorts of issues should be raised, because it is that jurisdiction that enables the court to do that which is, as it were, preventive of the expense of the litigation being prohibitive.
And you're saying that if it's not raised prospectively, then it cannot be brought into the equation retrospectively at the end of the day.
It becomes much, much more difficult to do.
But are you saying it cannot be done?
It cannot be done at the detailed assessment stage. We don't go as far as to say it cannot be revisited at the final award of costs, where, for example, a court has a series of powers to direct, as it were, percentage reductions, or even to say the costs that we award shall not be greater than X.
But it must be open to the court at the end of the day to decide what appropriate order for costs to make.
My Lord, certainly, we accept that. The question...
Are you saying the hands of the... I mean, it may not matter, but are you saying the hands of the court at the end of the day are somehow tied because of a decision that was made at the outset?
I don't make that submission.
No. I think rather it hasn't prohibited her, and therefore, by the time the litigation is over, then it carries less weight. That's what I thought.
It carries less weight, and it's important. It would be an important factor in the exercise of the court's discretion on costs at the end of the day that someone had not made an application for a PCO. I mean, suppose, for example, that someone just chooses, because they don't feel like it, they choose not to make a PCO at the early stage of the litigation. They then go through the litigation in its entirety, get to the end, and then make the submission, there should be no order as to cost because it's prohibitively expensive, or it would be. At that stage, I don't make the submission that they would be shut out from that submission, but I do make the submission that it would be highly relevant for the court to take into account both the fact that they hadn't applied for a PCO and also the fact that they hadn't in fact been, ex hypothesi by that point, prohibited.
All this slightly depends on whether the test is largely objective, exclusively objective, or the reverse, subjective. I can see the force of some of what you say if it's subjective, but if it's because you'd be entitled to assume that they probably felt comfortable with pursuing the proceedings and the costs involved or the risk of the costs involved. But if it's objective, then you must be taken to know that at the end of the day, the Aarhus Convention standard of objectivity will apply, so you can't be said not to be on notice of what's going to happen. And I imagine it might also be open to people in your client's position actually perhaps to apply to the court for direction, if it's objective, as to what would be the appropriate level of non-prohibitive expenses. I mean, that's a thought that one might just ventilate.
Well, that is, I'm sure, a possibility. One can always apply to a court for direction.
If it's objective.
If it's an objective test.
I think it'd be quite difficult if it's subjective because it's so much in the other sides.
Quite. And in any event, there are, even if it is objective, there are other issues that would arise in relation to protective cost orders. That jurisdiction would still exist. This is simply one component of it. And in my submission, you would still be in some difficulty if you'd failed to exercise or to invite the court to exercise a jurisdiction available to it. There may, of course, be the fallback position of the state itself or the public authority itself applying for a direction in that respect. But the natural jurisdiction, and a jurisdiction which involves a number of other features, is and should be the protective costs order jurisdiction. That is the principal mechanism by which the UK says it complies. And now that the ingredients of that may need tinkering, no doubt will be tinkered at some point. But that is nevertheless the appropriate jurisdiction, the appropriate exercise for the concerned environmental challenger to follow.
I mean, what happens if, as here, protective cost order is refused, and then they say, well, terribly sorry, can't go ahead, chuck it in? I mean, is that an automatic breach of our house?
My lord, no, I don't think it would be.
Well, how do you approach that sort of a case?
Well, it would depend upon whether or not, I suppose it comes back to the question whether or not it's objective or subjective.
Your attention, please.
I think we're going to have to break off.
Armistice Day, and in a few moments it will be 11 o'clock.
I think we needn't stand quite yet, but...
We will observe a 2-minute silence in memory of those who sacrificed their lives for us during wars. I will announce when it is 11 o'clock and 2 minutes past.
Well, I suggest we stand now and then we're...
It is now 11 o'clock. It is now 2 minutes past 11. Thank you for your observance.
Thank you very much.
No, sorry to come back to it. We wouldn't accept that the mere fact that someone chucks it in, as you put it, after an adverse ruling would automatically lead to a breach of the Aarhus Convention. What that convention does is to impose systemic requirements. There should be access to a set of review procedures or a review mechanism which is fair, equitable and not prohibitively expensive. And it cannot impose and does not impose, I submit, an obligation of result. It is rather an obligation of means, as Strasbourg would put it. You have to provide the processes within which those sorts of challenges can be made on a non-prohibitively expensive basis. The mere fact that someone says, well, I'm decided to chuck it in, doesn't necessarily lead to the conclusion there's a breach of that.
But it points to a more objective approach. And also, I mean, one really has to look at the overall picture, because you're not only concerned with the claimant in this case, but in future cases. And I mean, our claimants in future, having regard to the history of a case like this, are they going to be discouraged?
My Lord, yes, one will, certainly chilling effect is a relevant feature. I'm going to come, if I may, later to the objective-subjective test and whether or not Lord Justice Sullivan's...
I'm interested to hear you saying, referring to the chilling effect, because it seems to me, apart from whether it's subjective or objective, one also has to ask, if you're being very literal about it, whether prohibitive means tending to prohibit or actually prohibiting. And similarly with chilling effect, I mean, despite the chilling effect of our libel laws, people do actually, from time to time, make defamatory remarks.
Yes.
On the question of what prohibitive means, I've been looking at the three languages. It isn't the terminology used in any of the three of them. They all use terminology excessively expensive or excessively burdensome.
Yes. Well, that might rather tend to support an interpretation that didn't tie it directly to the actual prohibitive nature of it. Yes. Although I don't think we certainly haven't taken the full position, as it were, that what is needed is actual prohibition. Tending is probably sufficient, although one needs to be a little cautious about what does and doesn't tend.
Well, we've got quite a lot of ground to cover. We've reached
we've
March
reached the point
2007.
We have. And the submissions I was making on that were, first of all, that it was a carefully considered a ruling of the House. It was unsurprisingly done on the basis of the information before them, but it also no doubt took into account the fact that it was always open to her to come back and try again, as it were, on the basis of fuller information. And importantly, the parties were afforded a full opportunity in advance of this ruling, which they took, to make submissions on all the relevant issues, including the issues relating to the directive. And they specifically raised and responded to arguments about the directive about the application of the prohibitively expensive principle. And the House of Lords evidently concluded that it wouldn't be prohibitively expensive under the directive for no such order to be made in this case. Now, that prompted, as you will see from pages 49 through to 53, in effect, that prompted some further reflection on the part of the appellant. She then wrote a letter inviting the defendants, the respondents, to provide an estimate of the present and expected costs. That was no doubt prompted by my Lord's ruling on the 22nd, because that letter is written, see the first paragraph on page 49, on the 26th of March, a few days afterwards. That was then responded to positively by both sets of defendants, who gave details of actual expenditure to date and proposed expenditure in the future. What then occurred was not a reapplication to the House to reconsider their decision on the basis that she had now produced further information. What didn't happen, and it appears that this is what the request for estimates was teeing up, as it were. What didn't happen was that she then going back to the House and saying, well, I've now seen your ruling, You think it is relevant for me to disclose my means. I've asked the respondents what their costs are likely to be, and now I can make the submission, and here are my means to enable you to make an accurate assessment of it. Instead, as you will see, she wrote to the European Commission, pages 54 and 55, and you'll see the penultimate paragraph on page 54. The assertion over the page that the cost bill was likely to be somewhere in the region of 100,000, it's in fact a bit less than that. And you'll see in the pre-penultimate paragraph on page 55, final sentence.
Sentence beginning with the word although.
Yep. They're still querying whether she is or is not going to proceed, but certainly no reapplication to the House on the basis that she now realised that the House were interested in how much or what her means were, and were interested in the amount of the costs that she might have to bear. There was then full argument of the substantive appeal, and that led to the rejection or the dismissal of the appeal, as you see from the next page, page 56. You'll see the final part of that order adjourning the matter for written submissions to be made about costs within 14 days, page 56, last line. And there are then very, very full submissions, again from both sides, on that issue. The response appears to have been some
I was glancing at page 57, which is a response by the Commission.
Yes, that is referred to, I think, in both sets of submissions.
Yes.
You'll see, for example, on page 80, which is within her submissions.
Page right.
Page 80, paragraph 10. The matter has moved further on in Brussels, it says, bottom of page 79, and then referring to that letter, which is also included later on in this bundle, we'll come to it in a second. This states, says the second line, that the decision on the PCO in this case appears to the Commission to be a further example of the bad application of Directive 2003/35/EC. That is a theme that is returned to on page 86 within the appellant's submissions on costs, paragraph 24, about 6 lines up from the bottom of page 86. The Commission, aware of the background, has expressed specific concern.
Sorry, where's that?
That was bottom of page 86, 6 lines up from the bottom. The Commission, aware of the background,
Yes.
has expressed specific concern. But if one actually compares that with the letter itself, which you see on page 57, in particular the final paragraph and the final sentence, that is not in fact accurate. Any additional information, they say in the final sentence, you may wish to provide will be welcome. In particular, also clarification as to whether ex parte Edwards is a case we can raise with the UK authorities as a further example of the bad application and so on. So all that is actually being said in that letter is kindly provide us with more information so we can make a judgment, or at least you can make an allegation as to whether it is or it isn't. There isn't an expression of concern from the Commission that this is an example of a bad application.
But it's pretty clear that they think there are examples of bad application.
That is certainly true, but the question is whether or not this case is one of them.
Yes, I'm not quite sure you're right about that in view of the first sentence of the second paragraph.
I understand from your initial contacts.
You're not keen this specific case be raised, so it may have been saying we'd like more information, but we'd also like clarification as to whether you're still hesitant about us raising it. In other words, they may already have formed the view that it was a bad application of the directive, but does it matter?
It doesn't terribly matter, but...
That seems to be how Mr. Buxton read it, anyway.
It certainly was how Mr. Buxton read it, but the assertion is a pretty positive one in both the submissions I've taken you to, namely that this is the Commission having reached the view that this was a bad application. The least that can be said about it is that there was a weather question raised at the end of that letter, anyway.
At any rate, they were sufficiently interested to join this file to their main file, so that it was on in the bundle of papers that they were putting together on this issue.
As matters to be considered, as complaints to be considered.
Yeah. Yes?
You will see that the various submissions, again, perhaps unsurprisingly given what's gone before, address at some length and again in some detail the directive itself. See, for example, page 67 in the submissions of the respondents. And see page 78, paragraph 7 and following in the submissions of the appellant. Return to paragraph 24 on page 86, which we looked at. So again, there is a full consideration of the directive issue at the end of the proceedings in relation to the exercise of the court's discretion as to what order as to costs to make. And you'll see that the cost order that is ultimately made in the light of those submissions is at page 99 on the 18th of July 2008. And that order, in effect, rejects the arguments that were put forward for some sort of limit on the costs based upon the allegation that the matter would otherwise be prohibitively expensive. It's necessarily implicit in that ruling, i.e. that the cost should ordinarily, the rule should be followed, the general rule should be followed and costs follow the event, that the House was not satisfied that some overall reduction should be made to reflect the prohibitively expensive principle. Their conclusion was that she should bear the costs of those proceedings.
So you put it that way, the House, you say, was satisfied there should not be an overall reduction. But does that, and this, we're going to come to this, does that deprive the cost judges of jurisdiction when they come to assess particular items?
My Lords, I'm going to submit yes. But just simply on the effect of the order, what the Court has not done is to make any percentage reduction. And you will see from page 81, sorry to go back to the submissions, that a series of alternative arguments had been run. The first was that she shouldn't have to bear any costs. But then in the alternative, assuming they were wrong on that, see page 80, paragraph 11, the argument was that they should be limited to the costs of one respondent. Well, that was rejected by the order. That the cost should be limited to a percentage of the respondent's costs. That was also rejected.
So that percentage had nothing to do with the directive?
Well, my Lords, those alternatives we respectfully submit are the basis for those alternatives is asserted inter alia to be the directives. As one sees the structure of the submissions, the directive is dealt with in paragraphs 7 and 8, for example, in the lead-up paragraphs to these alternatives, and paragraph 10 referring to the letter from Brussels and so on, and then you're straight into the alternatives.
But the 70%, for instance, had nothing to do with the directive. That was a conventional sort of argument that they should only be entitled to a percentage of their costs because of some point which I don't I'm not privy to, but something about non-disclosure of information.
My lord, that's certainly true, but it raises at least the question about percentage reduction, and then you'll see the next bullet down, which invites the court to impose a financial cap, in effect, limited at 25,000.
The one thing which doesn't perhaps really emerge from this is the issue of objective-subjective, very clearly. It's touched on in paragraph 7, isn't it? Foot of page 78.
Yes, it is.
But that's about it. And
it is, although my lord will recall that there was an exchange of submissions at the earlier stage in relation to the PCO as to whether or not her means needed to be produced. Which
when the House clearly proceeded on the basis that it was subjective.
Yes.
I mean, if that's an important issue, and if the argument is that this second stage determines it, it's a pretty casual way of determining it, isn't it?
Well, my lord, this has got to be seen against the backdrop of the submissions that have already been made. I don't think anyone was backing off, as it were, from the submissions that had already been made about costs and so on. I mean, I'm not sure they were referred to by expressly in these later submissions, but these do sit against the backdrop of the earlier submissions that have been made on the PCO and whether or not matters should be disclosed or not.
Well, that too is wasn't a fully argued point, was it? It was more an assumption that, at least on your side and perhaps on the House's side, that subjectivity was relevant.
Well, my lord, yes, but my lord is entirely right, and it is fair, I think, to accept that the subjective-objective point was not argued in the way in which it evidently was argued in the Garner case before the Court of Appeal. Yes. There wasn't a title in any submissions here, I fully accept, that said objective-subjective, which is the right test. But that is, as it were, at the very least implicit in the exchanges that did occur at the earlier stage as to whether or not she should disclose her means. Mm. But you'll see, sorry, to go back to page 81, you'll see that various alternatives are advanced by her, including a suggestion that there should be a £25,000 limit so as to reduce the burden. And you'll see the final bullet, which indicates at least that the directive is still in the frame, albeit that the one that is tied to that is a...
Why do you say it's reduced to 25,000? Is that the penultimate bullet point?
Reducing the burden on the appellant by ordering any costs in excess of 25,000, yeah. I suppose to be payable by instalments.
Yes. It's quite different.
Yeah.
So no ceiling is being suggested. It's an instalment of 5,000 per annum up to whatever the figure would be.
It would have been entirely open to the court. There would have been nothing to prevent the court at this stage. There would be nothing to prevent either my learned friend raising a broader and overall percentage reduction as an issue, nor raising a financial cap or limit as an issue, and there would have been nothing in terms of the court's powers that would have prevented or could have prevented the court from adopting either of those courses if they had concluded that that was the right and appropriate and just answer in the case. Instead of which you've seen the ruling that the House made on page 99.
Yes.
You have the ruling of the costs officers in the bundle at tab 3. I'm going to come back to that in a moment, but the essential point is that they concluded that they could take into account the directives, they could conduct some species of prohibitively expensive exercise or analysis at that stage,
Paragraph
see
13.
paragraphs 17 and 18.
Yes.
But they also accepted that, to the extent that the House had ruled on the various issues, and that would obviously bind them, they'd have to give effect to that. That's self-evident, perhaps. So, my Lords, first of all, just to turn to the submissions, if I may, at this stage. First submission is that the House had, in fact, specifically considered whether orders were necessary or appropriate in order to give effect to the requirement in the directives that proceedings should not be prohibitively expensive. And the cost officers did, in my respectful submission, correctly note that if that was so, in other words, if the House had in fact done so, they would have no jurisdiction to reopen that point. That's obviously right. They're there to exercise the jurisdiction conferred on them by the rules in the light of and in compliance with the orders made by the House or by this court.
As a matter of law, if we were to conclude that the House proceeded on a basis which was wrong or within Sylphid, arguably wrong, could we, and in fact, would we have to do anything about it now?
My Lord, that is a thought that had occurred to us. We have a clip of materials, if we need them, on that issue. And the short answer, I think, to my Lord's point is that the view that we have taken on the submission that I make is that you could reopen. Perhaps could we hand up that clip?
I mean, we might even have to, might we? I mean, are we a Köbler court?
Well, yes, you're wrong.
There's no, I mean, Mr. Buxton has referred to
Köbler damages.
going to the administrative court, which is the usual jest in relation to Supreme Courts that will be overruled in the Hartlepool County Court. But, why shouldn't, I mean, we would have probably a Köbler obligation ourselves, wouldn't we, if we concluded that there was a point which we decided previously, which actually is a point which should have been referred to Europe.
My Lord, that is certainly an arguable point. It's teed up by Köbler, and it's also teed up by a case called Wells, which I know my learned friend is going to refer to. And that refers to there being an obligation on all responsible state organs, I summarise, but within their competencies. Yes. So there is still a question about the competencies of each level of the organs within the state. But I would certainly accept that it was arguable.
But we do have competence of a certain nature to, in some contexts, I haven't looked at the Pinochet case again, but that's the obvious example.
Quite, that's included in here. My Lord, I think if the clip has been handed up, you've got the Broome case, Castle and Broome, which was a reopening by the House of Lords of its orders on costs. Perhaps don't need to spend that long in relation to that. But then Lord Brown Wilkinson in Pinochet, which is in this clip. We haven't given you the whole case for fear of overburdening you with yet more paper, but Pinochet is the second case in here. It's at page 132.
It's the inherent jurisdiction point, isn't it?
Yes,
really?
between the letters C and F, you will see
Yes.
what is said by Lord Brown Wilkinson in that respect.
Is there not another way of looking at this, that if one looks at it as an estoppel point, if things have emerged subsequently, fresh evidence as an example, or some point which plainly wasn't addressed emerges, possibly wasn't available to be addressed, then one would regard the estoppel point as falling away.
My Lord, I think in principle we would accept that proposition. The question is whether there is some new and wild beast, as it were, out there, which wasn't there before, my Lords, when you made your original decisions. And part of the reason for spending a little time, for which I apologise, going through the chronology, was to indicate that at least the arguments were in the frame. They might not have been specifically and directly addressed. We've had some exchanges in relation to that, but the directive was certainly live, both at the PCO stage and at the order for cost stage.
No. I beg your pardon. I'm really, in a way, I think, picking up Lord Mance's point, that if at the stage when the House of Lords was making its final order on costs, it had been clear what the position was about the difference between the objective approach and the other approach. The view, one might suggest, might have been different. I mean, if it was plain that one had to take an objective approach to costs, it may have been easier for the House to take a different view. But if it was taking the view that it was all a matter of what the individual could pay, then because of what had happened in the case had gone ahead apparently without any inhibition on probative expense and so on, a different view would be taken. So it's that kind of point that I wonder isn't lurking behind this case, that things have moved on a bit in the thinking on this issue, at least to the point where we're now facing, as we will, as you're coming to it, I think, facing a real issue as to whether there's a point that requires a reference.
Yes, my Lord, I hope I have fairly accepted in exchanges with Lord Mance that the subjective-objective point, to use that perhaps inaccurate phraseology, was not, as it were, directly raised and directly argued in the way in which it was in Ghana. That is an inevitable acceptance on the basis of the papers. The furthest I can put it on the basis of the papers that you have before you, which is why I've taken you through the chronology in some detail, is that first of all the directive was plainly relevant there and being argued about, and secondly it is evident that underpinning a lot of the debate that went on, particularly at the PCO stage, was the subjective-objective divide, in the sense that the parties were divided on the essence of that issue, which is whether or not there was an obligation on her, or a quasi-obligation on her, to produce evidence as to her means. But as again, I hope, my Lord, I'm sorry.
No, sorry. I was going to say, being strictly analytical, I suppose the first question is whether there is a binding decision, and then the second question is the one which your clip helpfully addresses, is if there were, would one have power to set it aside? And on the first question, Lord Hope's referred to the flexibility in issue estoppel, but I suppose there is a question as to whether we're talking here about res judicata on the issue of costs, or an issue estoppel. And as, if I recall rightly, actually res judicata is not so flexible. If you have an actual decision on an issue, that is it. Issue estoppel is
may contain a bit more flexibility within the
pragmatic, because it slightly depends on how the issues arisen and whether it's been argued. So, I mean, there might be that technical question which we needed to look at.
May I think about that a little more, because I think that neither side have squarely addressed that distinction in their written submissions.
Yes.
And if it's a matter of some concern to the House, to the Court,
well, I mean, I suppose strictly if one's reasoning it through, if it becomes necessary, one ought to get it right.
Yes, I entirely accept the order of the issues.
One bears in mind that we're now dealing with something at the level of the costs judges, as opposed to the order of costs itself. So there's that subtlety in the different level at which we're debating the issue now.
There is.
Which make it easier to address this as an estoppel point rather than the res judicata point.
Yes, I mean, there are also separate questions out there which are not necessarily directly linked to the issues we've just been engaged in, which is whether or not the costs officers in any event have a discretion to exercise this sort of jurisdiction when the matter gets to them. I mean, the case is somewhat complicated because it's, as it were, transitional in the broadest sense of the word. But if one was in the position of clarity or quasi-clarity on the subjective objective issues now, and a case was starting now, and one then posited the situation in which there had been this sort of process, you might end up with a very different answer, and it may be tempting but potentially wrong in principle to say, well, let's try and solve the problem by expanding out the jurisdiction at the costs officer stage in order to deal with the problem. We would urge some considerable caution about that because there will still, in the brave new world, need to be a process, competencies given under the domestic regime legitimately under EU law to do that which the national regime imposes upon them by way of jurisdiction. And we respectfully suggest that there may be a danger in the transitional element of this case and the temptation to expand out that last bit of jurisdiction in the costs officers.
Well, I mean, Mr. Reid, looking ahead, wouldn't you rather that we reopened our earlier decisions with a view to making reference to Europe, redeciding the matter in the light of any assistance we get from there than doing what you're really fighting here, which is, as you would put it, no doubt, distorting the process of taxation in order to accommodate the problem that we've got into.
Well, yes, I'm going to come to that at the end if I may, but my submission is going to be that if you are at the stage of being genuinely concerned about, for example, a subjective-objective issue, the appropriate course is not, as it were, to expand that jurisdiction artificially, but would be to either make a reference or reopen your earlier order. Anyway, on the jurisdiction point, we've got Pinochet and got Lord Brown-Wilkinson you've seen, so that would open it up if it was the House of Lords on the House of Lords. The slight wrinkle is that you are, of course, now the Supreme Court.
I think we've inherited
my Lord, well, it's very easy at this level because
How do we affect something across Parliament Square?
quite, but subject to legislation, it's very easy to make the submission that you are legally omnipotent at this level of the court hierarchy. My Lord, the closer we've come to at least provide some things for you to think about in terms of that Supreme Court versus House of Lords question is paragraph 5 of Schedule 10 of the Constitutional Reform Act 2005. We're now down in the nether regions of the transfer.
Which are we in one?
That's in the clip as well.
Pardon?
It's in the little clip I handed
the little
up
clip.
with
I'm so sorry.
We've, I hope, helpfully collected together all the relevant materials on this issue
Right.
in the little clip. So that's the third of the stapled documents, at least if yours follows the same as mine. And the relevant paragraph is paragraph 5 of Schedule 10.
Yes. So we're inheriting the jurisdiction the House had.
Yeah.
Well, except our previous judgment apparently counts as if it's an act or judgment or order of the Supreme Court here, so that we can deal with it.
These proceedings are in effect transfer proceedings.
Effectively, without anything being done in the paperwork across Parliament Square.
Yes. And you'll see from paragraphs 1 and 2 of Schedule 10 that these are in effect transferred proceedings. And you'll see finally on this Rule 55 of your rules, which is the last clip in the bundle. So I think the argument on your having power to do that would run something like the House of Lords decision is now treated as a Supreme Court decision. The Supreme Court is the final court of appeal and also has inherent jurisdiction to reopen its own decisions. And own decisions includes decisions on transferred proceedings. I hope that's helpful. I can't remember what I said. On the first submission, can I go? Oh, you're pausing.
I thought we had a general power somewhere to do everything in order to achieve a just result. I'm guessing to exactly where it is, but is it in the Act or in the rules?
Or maybe it's in the rules. Can we check? I'll get someone to check that while we. Whether you need to resort to that in the light of these is perhaps questionable. We'll see if we can find something to that effect. An expression of general omnipotence.
Yes.
Well, it was on the submission that the House had in fact specifically considered it and had indicated the consequence, which we respectfully submit the cost officers rightly acknowledged, which is if you had dealt with it, then they wouldn't have the jurisdiction to reopen that issue. I've referred already to the March 2007 ruling, and perhaps 4 short points in relation to that. Firstly, this was, i.e. the PCO application, was the appropriate time to raise the prohibitively expensive point. That's the first point. All the factors that might be in play on this sort of argument, i.e. prohibitively expensive, were in place for the argument to take place at that stage. And specifically, of course, in relation to, and I'm talking more generally now, in relation to PCOs, but specifically in relation to the jurisdiction to make orders for protective costs, those are done in advance of the pursuit of the litigation in question, in essence. And in this case, that was the House of Lords proceedings. So if there is a concern about them being prohibitively expensive, that is the natural time at which to raise this sort of point.
Could we just go back? I'm sorry to do this, but
Yes.
go back to the Pinochet case. I'm not clear whether you're saying that we do have jurisdiction to revisit the matter on the facts of this case in the circumstances which have arisen. Because if you look at the whole of what is said on page 132, D, in principle, it must be that your lordships as the ultimate court have power to correct any injustice, refers to Broome and Castle, varied an order for costs already made by the House in circumstances where the parties has not had a fair opportunity to address the argument on the point. Should be made clear the House will not reopen any appeal save in circumstances where, through no fault of a party, he or she has been subjected to an unfair procedure. Where an order has been made by the House in a particular case, there can be no question of that decision being varied or rescinded by a later order just because it thought the first order is wrong.
Although that, in my respectful submission, my Lord is right to raise, I should have picked it up myself, but that is not, I submit, a point which is being made as a point about jurisdiction. It is a point that is being made about the exercise of that jurisdiction. Yeah. And what the House is, what Lord Brown-Wilkinson appears to be saying, if I've read it correctly, is that it's no good coming along in an ordinary case and just saying we think it was wrong. That's not going to form the basis for doing it. It isn't, as I say, a jurisdictional point, but how ordinarily they would go about exercising a discretion. And so my lead into this clip, as it were, was premised upon your lordships being really concerned about the subjective-objective issue, for example. And in those circumstances...
Sorry to interrupt you, but I understood you to say that although there were lengthy written submissions on both sides, that you accepted that that issue had not been squarely raised and covered in the submissions. Is that right?
My Lord, I did accept that. Yeah. It came with the rider attached, which was that the substance of that argument, disclosure or not of an individual's means, was squarely raised. Yeah. But I entirely accept that the matter wasn't put up in lights in the manner in which it was, for example, in the Ghana case. Yes. And that might impact on this also.
The substance of the point was squarely raised, but the considerations which bear on it either way weren't explored. That's the problem, isn't it? The arguments about the need to look at it objectively because of the chilling effect on other people.
My Lord, you've seen what was put in by way of submission, and by and large the Secretary of State was perhaps unsurprisingly in responsive mode, but that is entirely fair. And I suspect if one had the skeleton arguments of the advocates who appeared in the Ghana case, they would look remarkably different to the arguments that you saw in the clip behind tab 9 in the bundle.
There is a slight tension between the sentence immediately below letter D on page 132 and the final paragraph, because it's put really quite broadly, I would have thought, in that sentence at letter D, any injustice caused, but then the however paragraph is rather narrowing it down. I would have thought that if you accept the passage at D, that one can take a broader view as to the circumstances that might give rise to the exercise of the jurisdiction.
My Lord, I'm not urging you not to take that approach. The principle, in my respectful submission, is the one set out below the letter D in the sentence my Lord has identified.
Yes. And
the default rules of practice or how the House might go about exercising that jurisdiction is the stuff of the paragraph between letters E and F.
Well, the EU dimension really could come into play here, could it not?
Well, I've never read that passage in the speech of Lord Brown-Wilkinson as being intended to provide a full-blown fetter on the exercise of the jurisdiction. It's simply a helpful indication as to how the House might go about exercising the jurisdiction which it holds, which is in effect to correct injustice. And one can understand why salutary noises, if I can put it that way, without any disrespect of that kind, should be being put out in a judgment of that kind. So of the 4 points on the March ruling, the first one was that this was the appropriate time to raise it.
Yes.
The second point is that not merely was it the appropriate time for raising the point, but the point was in fact pursued as part of the arguments for and against the PCO and the waiver of the security for costs. We've had perhaps sufficient debate on the manner in which that was done, but the directive certainly was in the frame. The ruling which you saw at page 48, the PCO ruling by the House, this is the third point, stated in terms that no case had been made for saying that the proposed appeal would be prohibitively expensive, or that the directive would be breached if the PCO was not made. So the ruling itself deals with that point in terms. And this is the fourth point. This isn't merely a question of form when one looks at it from the costs officer's perspective going back. In substance, what the costs officers assert the power to do is to provide, as it were, an overall reduction to the bill otherwise reasonable, by reference to the prohibitively expensive principle. They assert the power to reduce an otherwise reasonable bill down to zero or to some nominal amount. And with respect, as a matter of substance, that is precisely what the House, right or wrong, that is precisely what the House, at the beginning of this litigation in Your Lordship's House, that is precisely what the House declined to do, concluding that it was neither necessary or appropriate to do so. And it is perhaps necessary to bear in mind under this head what would have been ordered if such a PCO had in fact been made. The parties to all litigation know that the usual rule, even in public interest litigation, is that costs follow the event. That means that the successful party is entitled to recover from the unsuccessful party their reasonable costs, I summarise. The focus, in accordance with well-established rules, is on the reasonableness of the expenditure of the successful party on costs when such an order is made, i.e. the usual order. And it is for that very reason that the parties seek a PCO. That's why they do it. Because PCOs in effect represent an advance exception to or protection against the usual and general rule. And they do so by imposing a cap on the fees that would otherwise be due. That's their very function. That would otherwise be paid as having been reasonably incurred by the successful party. And the effect, perhaps also to be borne in mind, of granting PCO orders of the kind sought by the appellant is and would have been in her case to cap the liability of the appellant in the event of a rejection of her appeal at a particular level. She suggested the figure of £10,000 and I think is now asserting that it should come down to zero. And the successful party, that is in our context and in most contexts of this kind, therefore the taxpayer, would not recover those costs as a result of that sort of cap being imposed, however reasonably incurred. And it follows from that very basic reminder of how these orders work that the House specifically rejected the notion that it would be either appropriate or necessary for there to be such a limit or cap, so as artificially to reduce the liability that would otherwise flow on an assessment.
Is there any quid pro quo for a cap? I mean, is there any consequence in terms of limiting the successful challengers' cost recovery?
Yes, you can make orders both ways.
But does one? I can't.
Yes, it's called a king cap, I think. frequently reciprocal orders are made. It doesn't necessarily follow that if the claimant's costs liability is capped at a particular level, that the defendant's cost liability will be capped at the same level. It is legitimate to take into account the fact that the claimant is normally an individual and the defendant is normally the state. But it is very frequently the position in these sorts of cases that there is, as it were, reciprocal capping.
So if you prove to be successful, you may actually have lost out through getting a cap.
Well, that's possible if you end up with reciprocality, but these things are always trade-offs in order to achieve a just and protective result.
I take it it's not automatic, though.
No, it's not.
And is there a case that you hinted at which says you can get this reverse cap or reciprocal cap?
I think it's called a king cap.
A king
with
cap.
Authorities, but it does happen very, very frequently. I'm told that Compton at tab 14 and bundle 2 deals with it.
Yes, thank you.
But certainly in my experience of these of cases in the administrative court, there frequently the argument is, well, if you're going to have it, we'll have one too. Thank you very much. And often that is successful, although it's rather rarer for the caps to be identical for the reasons I indicated.
Well, are those the 4 points then on the March?
Those are the 4 points on the March one. And in relation to the March one, it is perhaps worth examining why it was that the costs officers decided, and I'm purely on domestic law at the moment rather than travelling into European law, but why they decided that this ruling in March wasn't of
yes,
the kind that they accepted would cut out their jurisdiction. Their reasoning on this point is at paragraph 24 in tab 3 of the bundle.
not a final ruling, they say.
Yeah, it's perhaps worth reading 23 as well, where they say we neither have nor assert any right to set aside or vary any decision already made by the law lords or by the justices in this case. If, in advance of the hearing before us, the law lords or the justices had made any decision on the implementation of the EU directives in this case, we would, of course, act in compliance with that decision. However, we take the view and so on. So they're accepting there rightly, we respectfully submit, that they've got to act consistently with the rulings that the House or this court has made. And then the reason they say that that principle is not in play is set out in paragraph 24. My Lord is right. I leave out of account the point about no oral hearing in the first line. That really doesn't take it much further, given the submissions that were made. There's no one who's ever asserted that was an unjust process, as it were, before the House. It simply decided the matter on the papers as it was perfectly entitled justly to do. My submission on that is that it doesn't, with respect, the rest of the reasoning, it doesn't, with respect, assist with or serve to answer the question posed. In other words, had they made any decision on the implementation of the EU directives in their case? The fact of the matter is that the House was asked to make a PCO precisely because it was said to be necessary to do so in order for the proceedings not to be prohibitively expensive. And precisely because it was said that the directive's implementation required that. And that fact is not altered by the fact that the appellant had chosen, no doubt having taken careful legal advice on the point, not to make disclosure of her means. Nor is it altered, we submit, by the fact that the House inevitably thereafter had to make its decision on the PCO in the light of the material that was before it. It's also to be noted on this reasoning in paragraph 24 that the decision on the PCO was indeed a final decision on the issue whether a PCO should be made.
But surely, aren't they right in saying that the wording of the order really invites a fresh order? It wasn't intended to conclude a further application. What it was saying was on the present position.
My Lord, I entirely accept that. The House did not necessarily rule out further information being put before them. They simply said there was no basis on the information that was before them, that they didn't conclude, or they concluded that a PCO would not be appropriate.
What do you say concludes then?
The fact that no such invitation, if implicit it was, I mean, there might have been a fight about whether or not they could go back and reopen afterwards, but I doubt that would have received a very sympathetic hearing in the light of the ruling. What I say closes off this PCO issue is the absence of any attempt to react to that ruling by coming back and saying, we've seen your ruling, you said that in effect you said our means are relevant.
That's the point, isn't it? You're saying then that it prevents or acts as an issue estoppel on the single issue whether the test is subjective or objective.
Well,
by implication.
Yeah.
Are you saying that?
We say, in relation to this decision, that it was final to this extent, that even though the House of Lords might well have left open the door for a further application, what shut that door was the failure by the appellant at any stage thereafter to turn up and say, I've seen the invitation, if invitation it was, here's my statement of means.
No. In other words, the only thing which it didn't close off was the possibility of an application made accepting that the test is subjective. Maybe. So it's a ruling on subjective objective. Yeah. And that's the point. And that is a pure question of issue estoppel, isn't it? That's not raised. So one has to decide whether that should bind in the present circumstances.
Oh, yes, it raises that issue of principle, but it also addresses, as it were, the correct self-imposed test that the costs officers have asked themselves in paragraph 23, which is, has the House ruled on these sorts of matters so as to preclude us from going back and exercising effectively the same jurisdiction again at the detailed assessment stage. And we say, respectfully, that the reasoning that they put forward in paragraph 24, which is in effect this wasn't a final decision, is not a fair reflection of what the House had done, because the House may have left a chink of light in the doorway, but the door was very firmly shut when the appellant decided not to seek to reopen it.
If you ignore the last three lines of the ruling on page 48, that's leaving aside the directive, it would be a fairly standard ruling on an application for a PCO, which wouldn't be a final order, would it? Because presumably one could come forward at some further point in the litigation and say, well, my circumstances have changed dramatically, and really now I'm in a position where I need to ask for this protection because I couldn't proceed to defend my position or advance my position without one. So it wouldn't be treated as a final order, would it, to that extent?
My Lord, it wouldn't to that extent. You could come back if you wish to and make further submissions on the basis of change of circumstance.
Yes.
There's a slight air of unreality about this, because the one thing that in my respectful submission can't be implied into that ruling is, as it were, some form of implication that the House was in some way leaving the imposition of a cap over to the end of the proceedings. So it wasn't by this ruling saying, well, you've applied for the PCO, don't really worry about that, because you can come back and make exactly the same points later on. If it was leaving the door open, it was leaving the door open to the appellant to come back and say, perhaps also change of circumstances later, but to come back and say, I'd misunderstood what the applicable principles are or should have been. I now see from your ruling that you do think my means are relevant. Here is a statement of my means. We invite you to reopen that issue and to exercise your jurisdiction. What isn't being done here is to say, well, you don't need to bother about a PCO, you don't need to bother about all that anymore. You can just leave it on one side, not come back, not introduce evidence as to your means, even though we've said it's relevant, and then rerun effectively the whole series of points again at the end of the process. And it comes back to the point, I mean, subject to potentially to changes of circumstance, there is an element of fairness in requiring people who are going to make PCOs to do so at an early stage of the very early stage of litigation. I mean, it might not in some cases affect how the defendant conducts matters, but if the defendant does know that costs are limited to a certain amount, that could in certain circumstances have a material impact on how they fight litigation.
I mean, it seems to me that the later order is altogether more important and concentrating on. I mean, when the submissions came to be made after the hearing as to the final cost order, I mean, to what extent were you saying, oh, well, now you're too late, it's all, you know...
No, that point wasn't made.
No, well, I didn't think it was. But if that wasn't your case then, I'm not quite sure, you know, why are you making so much of it now?
Well,
We just need to glance at paragraph 27, don't we? Or perhaps you're coming to that, are you?
my lord, I am, in the context
right.
of the 18th of July.
Yes,
Can I come to that now? I'm sorry
Right.
to have delayed unnecessarily if I have on the March order.
Yeah.
But the July 2008 ruling is the final order on costs.
Yeah.
But no point was taken that it is now all too late. Although, in fairness, my learned friend was right on page 79 to be sensitive to the fact that he was re-arguing points that had been raised earlier and apparently rejected. See paragraph 8 on page 79. Final sentence. Page 79, paragraph 8, final sentence. But it is right to point out, and we accept, that no point was taken about it being too late.
Yes. Yes.
But you will see that on that reasoning, in the argument that was developed at that stage, it was very, very similar looking indeed to the arguments that have been deployed earlier on in the context of the March 2007 PCO application, specifically running prohibitively expensive again. I mean, might be thought against the relatively unpromising backdrop of not in fact having been prohibited. And then a range of options sought as an alternative. However precisely those were put, the range of options that was open to the House at that time was, or included, a percentage reduction, an order that the costs should, on prohibitively expensive grounds, be capped at a certain level, i.e. no more than 25,000 or 10,000 or whatever it may be. All those options were open to the House at that stage. My Lord Walker reminded me, and I was going there anyway, at this point, paragraph 27 of the costs officer's reasoning.
Yes.
In my submission, the key point which is being made is that they didn't expressly deal with it. The House didn't expressly deal with it, but simply made the order that they pay the respondents' costs. Really isn't an answer to the question, did the House consider arguments about the directive? It is clear from the order that was made, without it needing to be expressed, that the House rejected the points that were made in relation to the directive by the appellant, and they also concluded, it is evident, that it would not be appropriate to impose what I call an overall reduction of any kind, whether by reference to a percentage or by reference to a capped figure for costs.
Or the kind of modification one sometimes get of reducing the liability to whatever percentage might be suggested.
Yes.
Plainly that isn't in the order.
That would have been open to the House. The House could certainly have done that.
But if the issue hadn't been considered and an order in these terms had been made, are you going to address us as to whether it would have been open to the cost judges to say, well, the order is in general terms, the point was not raised, and here we are now faced as judicial officers with somebody arguing that the convention should be applied to us at the assessment stage.
My Lord, I am going to address you on that, and my submission will be that they would not have jurisdiction to do that. They're there to exercise the limited jurisdiction that is conferred on them under the Supreme Court rules, which very broadly, and in some cases very specifically, but at least broadly, track CPR Part 44.
This isn't this case, but your argument would be that if a party doesn't raise it at the point when the order for costs has been considered by the court, then the pass is sold and it can't be picked up again.
As well, yes. But there is a prior jurisdictional point, which I think was the point my Lord Mance was on, in terms of the order of the, in terms of the logical order of the argument.
I mean, if they do have, in the ordinary case, jurisdiction to decide on reasonableness and proportionality by reference to our House Convention considerations, so if that is within the cost officer's jurisdiction, then you have to say that the House of Lords cost decision of July 2008, by implicitly proceeding on the assumption that the cost officers either didn't have that jurisdiction or wouldn't be exercising it, effectively precluded them from exercising it.
Well,
is that right?
That's how the argument has to work. But it starts with the jurisdictional point under the rules, as my Lord rightly pointed out.
Yeah. Or alternatively, perhaps you can put it slightly more attractively by saying that the House of Lords effectively tacitly exercised the jurisdiction for the cost officers, i.e. they considered whether this is a case where you should take account of our House Convention considerations at all. They decided not, and it's as if they gave a ruling to the cost officers.
Oh yes, they don't. What they don't need to do, I entirely accept that as a more attractive way of putting the same point, but what they don't need to do, the House, is to deal expressly with the points. I mean, the House has frequently produced rulings of this kind in the past, and has done so, again, very frequently, is my understanding, on the basis of precisely this sort of process. In other words, detailed submissions that the jurisdiction should be exercised in a different way, in a more nuanced way, in a way which indicates that there should be some overall limit. Forget about whether costs as incurred by the successful party were reasonable or not, some cap or overall reducing feature. And as far as I'm aware, it is very rare for the House to give reasons, for the House to have given detailed reasons for its cost decisions. More often than not, the rulings do come out in this manner. But there is no warrant from the fact that points aren't expressly dealt with for concluding that the House didn't consider, and consider carefully, all the arguments that were deployed before them. Now, that doesn't answer the question, how squarely was the argument raised and so on, but the assumption that lies behind this sort of order should not be that unless a point has been dealt with expressly, it hasn't been properly considered and, as it were, implicitly or otherwise rejected. The working assumption should be that the House did carefully consider all the submissions that were put before it and has chosen simply to express its reasons in this form, its conclusions in this form.
This general point applies not merely to the House's rulings, our rulings and our own procedural rules. I mean, it's exactly the same for orders made in the Administrative Court, Court Appeal and everywhere else.
Yes.
I think there might be a slight difference in that in some of those courts reasons are given.
Sometimes.
Well, it has definitely been said, hasn't it, that if a court makes an unusual costs order, it should give reasons so that the parties know why that order has been made. And
yes,
there's a good deal of sense in that, isn't there?
Quite. But that wouldn't apply to the situation that we have here, where the general rule is followed and the usual order is made. And my submission is that the working assumption must be that the House properly and fully considered the arguments that were before it. My Lords, once that sort of order has been made, what that then does is to leave the amount of the costs so ordered to be determined. And that is a point that the costs officers make in paragraph 27 as well. And that is, of course, true, but it is incomplete. Orders can be and are made in this form on the basis that the process that would then be followed is the usual one in the rules of determining the reasonableness of the costs incurred by the successful party.
And you go to the rule, do you, which says that in the absence of any other direction, it must be taken to be a direction to assess on the standard basis.
Oh, yes.
That's what the rules say.
They do, and I'm going to come to them in a little detail in a moment, but there is no basis under the rubric of this sort of order, and there's no basis under the rubric of such reasonableness assessment for the assessing court to impose the sorts of caps or percentage reductions that fall squarely within the jurisdiction of the court. Can I put that point, I hope succinctly, in this way? The jurisdictions exercised by the court and by the costs officers are complementary but not overlapping. And my lords, as we understand it, and I introduce it in that way with some trepidation, because almost invariably when one goes to a decision of a judge who's sitting on the panel, you're told that isn't at all what he intended to say or what he meant. But with that precautionary note, can I go to the decision of, I think Lord Justice Dyson, as he then was, in Leahy and Pirelli, which is in Bundle 2, tab 13.
This is your time.
I'm very happy to read it out if you'd like me to, but perhaps it may be more convenient to invite you to read the head note, which is relatively brief, and in particular then to read the finding or the holding of the Court of Appeal. My lords, the relevant principles are, we respectfully submit, to be found in paragraph 20 in particular. There is a real distinction between and this is Lord Justice Dyson giving the judgment of the court, as you see from page 1000. There is a real distinction, paragraph 20, between A, carrying out an assessment and deciding as part of the assessment to reduce the bill by a percentage, and B, deciding in advance of the assessment that the receiving party will only receive a percentage of the assessed costs. The figure that results from A represents 100% of the assessed costs. In deciding as part of the assessment to reduce the bill by a percentage, the cost judge is giving effect to an order that the successful party is entitled to his costs to be assessed if not agreed. The figure that results from B represents less than 100% of the assessed costs. In deciding in advance of the assessment that the receiving party will only receive a percentage of the assessed costs, the cost judge is not giving effect to an order that the successful party is entitled to his costs to be assessed if not agreed. And what runs through that paragraph is a recognition that the jurisdictions being exercised by, on the one hand, the court, and on the other hand, the costs officer or the cost judge, are different.
But this would be on a proposed reduction on account of some factor which didn't bear on the reasonableness and proportionality of the costs themselves, but related to the conduct of the litigation, the offer, is that right, or failure to accept?
My lord, that's the specific context of this case, and that is entirely fair to point out. But my lord, Sir John Dyson is nodding, so I'll take that as confirmation directly.
So it's rather different, because I mean, you undoubtedly could write into the rules. The question is whether it is there. That in deciding what's reasonable, proportionate, you must take into account what would be excessively onerous.
Well, my lord, you could change the rules in that respect, It would require a change in the rules, in my respectful submission, and that is no doubt what is being carefully considered as a result of matters I'm going to come to in a moment by the government, but it would require a change of the rules. What this is doing is, this passage in the judgment, is to consider the respective splits in terms of jurisdiction as between cost judge and court under the rules as they currently stand, with the division of functions that exist.
But what is one to understand by the phrase assessed costs? I'm asking you, in a sense, it's a question for all of us, but if one contemplates what the cost judges do, they're presented with a whole list of items of expenditure, fees, outlays, and so on and so forth. And the exercise, as I understand it, is to look at each of these items.
Yes.
And it may be that some of them will be struck out as simply things that shouldn't be attributable to the losing party at all. There may be other things that are modified and reduced because it's thought that the expense is unreasonable and you could reduce it to a different level. But is there anything to prevent the cost judges from saying, well, we look at this bill overall, and really, we think that without going through all the things item by item, it shouldn't be reduced by a given fraction or percentage just to bring it down to what overall would be a reasonable bill.
Well, my Lord, they can
conduct
conduct that sort of exercise because they can, as I understand it, start from the proposition of looking at the proportionality of the bill overall.
Yes.
But they do so with a fundamental focus upon the reasonableness of the items of expenditure and of the amount, the total bill of costs presented by the successful party. It is a very different exercise in my submission for them to say, well, because of matters which have really nothing to do with the successful party or the reasonableness of the particular item of expenditure, whether or not it should have been incurred, whether or not it's reasonable in amount if it is properly incurred. It's a very different matter to jump from there to say that because they can look in that context at the overall proportionality of the bill when coming down to the items and working that out, that they should thereafter also be entitled to turn around and exercise a jurisdiction which is fundamentally differently focused.
Well, I can perhaps put the point a little more sharply this way. Would it be an illogical order for a judge to say that the cost shall be assessed on the standard basis, bearing in mind the Our House principle that the costs overall shall not be prohibitively expensive? That's built into the order, and the judge can't actually conduct the exercise because he doesn't have the figures, but he's leaving it to the cost judge to build that into their overall assessment. Is that something that you would say is just simply unacceptable? Because
My Lord, I do say that's unacceptable under the rules as they currently stand. That is why the government is now seriously considering how, if at all, to change the rules. That is why one has the reports from Lord Justice Jackson and from Lord Justice Sullivan saying, here's how we're now going to alter it. I'm going to come on in a moment to Section 11 of the Access to Justice Act 1999, but you'll appreciate that in the legal aid context, there is a specific legislative provision entitling the court to do precisely what my Lord has put to you, in effect, which is to say, let's have a test based on reasonableness as well, but based on a very differently focused type of reasonableness, namely, what is it reasonable for this particular claimant defendant to pay? That is a fundamentally different exercise to the exercise that the rules as currently framed envisage.
But that's also a different exercise on one view from the Our House exercise, because if you correctly represented it, it's a subjective exercise. What's it reasonable for this defendant or party to pay? And I can see that if the test is subjective, to treat the cost officer's jurisdiction as embracing Our House considerations is very difficult. Nobody will know in advance what the subjective position was unless there's some order, and even at the cost officer's stage, it expands the scope of inquiry enormously. But if the test is objective, then it's easier to see how the concept of reasonableness and proportionality might extend not merely to look at the conduct of the person expending the costs, but also to take into account the burden which is fair to impose in relation to litigation of this size on the losing party.
Well, can I answer that in this way? I, of course, accept, because it follows the matter of logic, that if the test is an objective one and not a subjective one, then that diminishes the nature and scale of the problem, which is whether or not you can shoehorn that sort of analysis into the rules as they currently are framed. Not as they're proposed to be framed, not as they may be changed to, but as they are currently framed. However, my submission is that although the problem might diminish on the assumption that the test is an objective rather than a subjective one, it doesn't deal with the problem.
Proportionality under CPR is much more concerned with how much is at stake to the parties in the particular case. And I've a rather vague recollection that there was a judgment given by Lord Wolfe when he was Master of the Rolls in the early days of CPR, saying that proportionality must be, it can't be dealt with in the sort of overall way that Lord Hope suggested would be.
My Lord, I think the passage you may have in mind is in paragraph 15, if you still have Leahy and Pirelli open.
Oh, yes. Right.
I suspect, I don't know whether my Lord has this in mind, but is it the quote that is in paragraph 15?
I think, thank you very much, I think it is, yes.
But my Lord is right.
Except Lord Wolfe was then Chief Justice and not Master of the Rolls.
Subject to that minor and forgivable slip of recollection, my Lord's recollection is impeccable. It was 50. It is the passage in paragraph 15, but my Lord is right to emphasise that. What is not permitted under the rules, we respectfully submit, is for the cost judge to in effect replicate the jurisdiction which is available to the court.
Yeah.
Could a cost judge just turn round and say, well, you've made an order that they pay all the costs, but I conclude, whether on proportionality grounds or on prohibitively expensive grounds, perhaps matters not for the purpose of this point, but I conclude that actually only half should happen. If so, that would involve him going through the traditional exercise that costs officers and cost judges do, which is to go, as my Lord Hope rightly identified, through the cost bill to make some broad assessments, if appropriate, in relation to the expenditure of the successful party, to get to the end of that process and to say, well, doing that exercise, I get to a figure of 20,000, 50,000, take a figure you want.
Yeah.
And now, halve it.
Yes.
That's a fundamentally different exercise, and that is an exercise which, in my respectful submission, is for the court to exercise. Because the court has the tools to do it. It has the tools to do it at the very early stage on PCOs, but also at the stage of making an award of costs at the end of the day.
But that again raises the issue about the nature of the information the court must have before it, because there is a different exercise, isn't there? If it's to be conducted on a subjective basis, then a great deal of information would be needed before the court could make some kind of direction. It strikes me as a rather unusual task for a judge to have to perform. Where it may be easier if it's an objective basis, some kind of overall view could be taken. But you're really suggesting, if I've understood you correctly, that it's for the judge to make the order, and it's not enough for him to simply say, apply the principle. He's actually got to be specific, either as to the percentage or even the given figure, which should be regarded as the maximum figure that the cost judges could arrive at.
My Lord, yes. That is his jurisdiction to exercise. It isn't appropriate, my respectful submission, under the rules as they currently stand, which is why the changes are needed, if they are. But it's not appropriate for the cost judge to do the exercise, go down all the figures, get to 50,000 and then say, I'm going to halve it. And my Lord, I was thinking, as my Lord was asking the question, whether it is such an unusual exercise for a judge to do. After all, the appropriate time at which this sort of issue is most naturally and properly to be raised is at the very outset of this litigation. I mean, there might be excuses for not doing it then and for coming on at the later stage when the proceedings have finished. They have been fought and the person has not in fact been prohibited. But the appropriate time to raise it is at the outset, and at that stage, my Lords, the court traditionally does receive precisely this sort of information.
I think I made that point in paragraph 21 of the...
My Lord, yes, I'm sorry, I was on 20, but I would invite you also to read 21 and 22 and 23.
Well, he can't carry out a detailed assessment, but then he has information which can enable him to go to a certain distance at least.
Yes, and the question is, what is the permissible limit to which he can go? My Lord, Sir John Dyson is entirely right. In particular, the last two sentences of paragraph 21, I think, my Lord, are there.
In paragraph 23.
Oh, yes.
But, I mean, I fully understand the point you're making in a, as it were, domestic context. I'm sure what you're saying must be right. But given the imperative to interpret instruments and legislation, and it must extend to rules, I'd have thought, conformably with EU law, leasing and all the rest of it.
Yes.
What do you say to the submission, I think it is going to be made on the other side, that the cost judge, like any other court, is required, is positively obliged to give effect to an EU directive, and that the rules which give the cost judge the appropriate jurisdiction must be interpreted conformably with the directive, unless it is literally impossible to do it. And I think the argument is, well, the concept of reasonableness is a fairly broad concept, and although in a purely domestic context you wouldn't entertain the notion that it would extend as far as it is being contended that it does, but in this context you can do it.
My Lord, I'm going to come to that, if I may. The short answer is going to be that the Wells case upon which that submission is founded allows domestic systems to respect their own internal competencies. And we are in the slightly strange position wherein we are, as it were, a transitional case. And the question is whether or not one can expand a jurisdiction which, if I'm right on the prior argument about domestic law, is not suited for that purpose. Can one use that rubric to expand it to include that purpose? And there are some serious questions about that, including constitutional questions about whether or not, assume I'm right on the prior stage about domestic law, it is open as an interpretive exercise to the court to do that, rather than, as it were, to have changes of the law and so on. But I'm going to come to that. I'm well alive to the fact that that is a point that is being taken. My Lords, on Leahy and on proportionality, and the point that my Lord Walker was making about proportionality, can I give you one other reference, which is in the tab before, the one we've just been looking at, tab 12 in that bundle. This is the Furry case, and the relevant paragraph is paragraph 39.
Which tab? I've lost.
No, I'm sorry, tab 12.
12.
Yeah, effectively making the point towards the latter half of that paragraph that the criterion of proportionality is in effect just an aspect of reasonableness, isn't introducing some new and freestanding test. It's the point I think that Lord Walker was on. My Lords, can I give you the relevant rules? I can take this relatively quickly, I hope, but it would be as well for you to have the rule structure in mind. Tab 20 in the same bundle are the Supreme Court Rules 2009. As you see going on the page numbers on the very bottom of the page, page 589, you'll see at the top of that page the derivation of those rules. They're made under section 45 of the Constitutional Reform Act 2005. That section gives the President power to make rules after consultation with the Lord Chancellor, and these rules were therefore brought into effect. They came into effect by virtue of a statutory instrument, SI 2009-1603, and they came into effect on the 1st of October 2009. If you go on to page 594, bottom right-hand corner of the page, you'll see the very broad jurisdiction to make orders as to costs that is conferred on the court. Rule 46.1. And that appears to have been used as a shorthand, but certainly we would respectfully submit at least would include power to make the sorts of orders that are set out expressly in relation to the lower courts in the CPR. If you just keep a finger in there for a moment and go into tab 22, you will see, again, page numbers on the bottom of the page, 634, within CPR 44.3, perhaps note en passant, as it were, 44.31 and 2, but then 6 on the next facing page, proportion of another party's cost, stated amount in respect to another party's costs, and so on, the various options that are available expressly, as it were, to the lower courts. 44.3, subparagraph 6 on page 634.
Yes.
You see the various types of order, but I don't think anyone is suggesting that the rule in the Supreme Court rules that I took you to, Rule 46.1, going back into tab 20, is anything more than a shorthand expression, as it were, that would include the power to make those sorts of orders. So, for example, it would be entirely open to the Supreme Court to order that 50% of costs be paid, or that only £20,000 worth of costs be paid. There wouldn't be any jurisdictional difficulty with that.
Yeah.
I mean, assuming reasonable and proportionate, as Lord Bingham said, much the same. I mean, to what? Proportionate to what?
To the issues in the case, in particular to the issues in the case, I think. But the focus, as I say, fundamentally is on the reasonableness and proportionality of the bill of costs presented by the successful party.
It was Lord Scott, wasn't it?
Yeah.
One wonders whether Lord Wolfe...
It was Lord Scott in the paragraph you referred
One
to.
wonders whether Lord Wolfe would have agreed.
Yes, I doubt whether Lord Wolfe would agree, actually. I think the idea of proportionality is meant to be something a bit different from reasonableness.
Well, there is still, even if that is right, there is still the question as to the focus of the proportionality exercise, and one comes back again full circle.
The whole idea, as I recall it, and I seem to remember being in one case, but it was to take a grip of cases where costs have got totally out of relationship to the amount in issue.
Yes.
And for courts to say in advance, it never happened in practice, sorry, the amount of costs that are going to be recovered in this case
Is X.
X, no more.
Yeah. Sorry, just in the Supreme Court rules then.
Yes.
You'll see the process set out in Rule 48.1, claim for costs being submitted to the registrar. There's a practice direction in the next tab, which we perhaps don't need to go to at this stage, but they're setting out how that should be structured and what items should be included.
Yes.
Rule 49.1, every detailed assessment of costs should be carried out by 2 cost officers and so on. And then you'll see the basis of assessment, which is dealt with in Rule 50. Effectively replicating the CPR, standard or indemnity. And the default position is standard, as you see from 50 subparagraph 2. And you'll see the nature of the test, which is perhaps the most relevant one, the nature of the test at paragraph Rule 51.
Yes.
That's really at the nub of it. Here the order was for standard basis only if they are proportionate to the matters in issue and are reasonably incurred and reasonable in amount. So it's matters in issue to which the proportionality analysis is directed, and it is reasonably incurred and reasonable in amount. And I respectfully submit that that does squarely put the focus on the nature of the item of expenditure and its amount, which the successful party puts before the costs officer. That isn't a warrant properly for introducing, as it were, that exercise with a gloss at the end, which allows them to go back, focus on something completely different, i.e. how rich or poor, or what the objective standard might be in terms of richness or poorness of the particular unsuccessful party, and then say, I'm going to halve it. there is also the question which is raised, if they are allowed to use prohibitively expensive, which is, well, how are they going to do that? The costs officers said in paragraph 17 of their ruling that they would disallow any costs that they considered to be prohibitively expensive. That is a very difficult exercise to see how they could go about doing that. Well, entirely sure what was envisaged. I mean, maybe their imagination is far greater than mine, but would they look at an item of costs that the successful party had produced or incurred, instructing an expert, say, well, we think that was a reasonable amount for them to pay for an expert. We think that that cost was necessary because there was a live expert issue in the case. So applying the standard approach, we would allow it. But now, we're not going to because it would be prohibitively expensive.
Well, they would surely not do it to individual items. They'd have to do it on a global basis.
They would.
But I mean, don't forget that what your submission is, that's what the judge or the Court of Appeal or this court should be doing. And how is it going to do it? Well, possibly with some help from Europe. But I mean, it's got to do it.
It may have to do it, but it is for it to do it, and not for the cost officers to do it. But I mean, my lord is right. I mean, they would do it.
It's impossible for them. It's impossible for us. So I mean,
well, except for the fact that it would involve. My lord is right, and we accept and assert that it would involve a global reduction or a global cap. It isn't focused on individual items of costs, and the courts are already engaged in that sort of process. They do already have to grapple with that sort of thing because PCOs are regularly made to them. And these sorts of issues are grappled with. Where should we put the cap? Should it be 5,000? Should it be 20,000? How do we go about doing it? It doesn't necessarily touch or answer the question that I know my Lord Mance is interested in, which is the objective-subjective. But that is an exercise which courts currently do under the PCO jurisdiction.
theoretically, I suppose, I don't know, cost officers might know more than courts about, what is the sort of cost that you expect to get at the end of the day in an environmental challenge of this nature. Is that the sort of thing that seems to be going on and that the challengers seem to be prepared to accept and this sort of thing?
Well, my Lord, I'm not sure I would necessarily accept that they would be, assuming all other things were against me, that they would be better placed, as it were, than a court to make those sorts of overall judgments. And presumably, particularly if one's going perhaps to wander down the road marked objective rather than subjective, it may be that those sorts of issues will need to be thrashed out by reference to precedent, and you'll end up with something which looks either like a range or a single figure or something.
Yeah.
But those are matters which are peculiarly appropriate for being dealt with by the courts rather than on an individual basis with much less publicity, as it were, and so on.
Speaking for myself, I can't see there's anything fundamentally wrong in paragraph 17. As it were, as an exercise that a costs judge can carry out. They're really telling us that's what they're proposing to do, and it's going to look at particular costs and maybe items of outlays which really wouldn't raise the issue at all. But then you come to counsel's fee, a brief fee or something like that, and they may say, well, it's a very, very big figure, and perhaps if we hadn't been instructed or guided by Aarhus, we would have allowed this. But because of the Aarhus principle, that figure really is prohibitively expensive, and we'll tax it down. I don't myself see what's wrong with that, if one's permitted to read Rule 50, let us say, in the light of the convention.
The days of an unusually and unreasonably large brief fee for me, I'm afraid, are long gone. But
yeah, well, the House of Lords had to address that issue, you may remember, not very long ago.
The difficulty, perhaps, with that is how do they go about doing the selection? We respectfully submit it would be extraordinarily difficult to know which item to focus on.
Well, until you see the items, of course, one's speculating entirely in the dark. But I mean, these are experienced people who've seen many, many bills and taxed them many, many times.
Of course, but if they were to reach the view that the brief fee was unusually large or unreasonably large, having regard to the issues, they would be entitled to reduce that in any event under the exercise of the reasonableness jurisdiction.
And surely there's this point that if you look at it on an individual item basis, you're actually not doing what is required under Aarhus. Because Aarhus requires you to look at the overall proceedings and have an overall procedure for recourse, which is fair, just, speedy, and not excessively expensive. And to try and reach that result by picking off individual items is impossible, actually, unless you relate the individual items to the overall cost and see whether the overall cost. So you come back to the overall cost. And,
Well, you do.
Well,
in my
really,
respect,
you come back to the PCO as the way of dealing with it.
you come back to the PCO and you come back to the sorts of order that could, at least in theory, be made at the end of the proceedings.
Yeah.
But they are all exercises of jurisdiction which, under the current scheme, is a jurisdiction to be exercised by the court. And there are phenomenal difficulties, both in principle, I accept what my Lord Mance has just said, both in principle and also in practice, with trying to shoehorn this into an individual item exercise. But as I say, as I said very briefly in answer to my Lord Hope, the sort of situation that you posit could already be dealt with under the reasonableness analysis by a cost judge anyway, because it would look at the issues that were involved and it would say, I'm sorry, given those issues, this brief fee is unreasonably large, so I'm going to reduce it by half. They could perfectly happily do that, and they could take a percentage approach to that individual item. Yes. What they couldn't do is to go through that exercise and then slice it. I've made the point. Right. My Lords, you will also be aware, I've mentioned it already, but there is, as it were, lurking in the background, something at least of a constitutional issue, because, as my Lords will have seen, the rules of the Supreme Court, as indeed the CPR, are made by statutory instrument. And at the moment, there is at least one example. Indeed, the cost judges, cost officers prayed it in aid of their own position. But there is at least one example of a statutory provision in primary legislation that does do precisely the claimant-focused exercise that my Lord has referred to, and that is Section 11 of the Access to Justice Act 1999.
Yeah.
Give me a reference to that. It is tab 24, which is the first tab, I think, in volume 3. And you'll see in particular 11.1.
Yeah.
So my respectful submission on that is that it isn't a true analogy, which is the way in which it was treated by the costs officers, because it specifically refers to parameters of reasonableness that are different. It's referring to the paying party doing so specifically, and his position or her position. And on the contrary, not merely is it not a true analogy, but it illustrates that a specific and different sort of provision would be needed to permit this sort of exercise in the hands of the costs officers. And the same point can be made by reference to the Lord Justice Jackson report, which had a ghastly phrase in it, I think, of qualified one-way cost shifting. It's almost incomprehensible to anyone reading it, but appears to be remarkably similar, if not identical in substance, to Section 11.1. And the same point can also be made in relation to Lord Justice Sullivan and his updating reports.
Do we have references to those?
We do. The Lord Justice Jackson report is at tab 35 in this same bundle. Perhaps if you turn that up, I can give you briefly the references. The critical passage, so far as this is concerned, is, well, firstly, paragraph 4.1, page 1137, within tab 35, where he says he's quite satisfied that qualified one-way cost shifting is the right way forward. And what that means in practice and in substance, according to him, is paragraph 4.5, over on the next page, 1138. And you will see why I say that concept looks and smells remarkably like Section 11, because you see the formulation of the point there.
I mean, one thing, of course, you can say about Section 11, Jackson, and the updated Sullivan is they're not at the PCO stage, they're at the post-hearing stage, are they not?
Well, they are at the stage of, I suppose, yes. I mean, they're not specifically, they do in other parts address PCO, but this part of it, I accept, is later on in the piece.
Because at that stage, at least we've got the advantage of knowing how reasonably everybody's behaved.
Yes.
Yes, conduct.
And if, you've got an effective overall procedure at that stage, well then, because you're looking at this on a sort of strategic global level, you're meeting the Aarhus requirement that, people are going to know, even if they go into it without a capped costs, it's going to be okay in the end.
Yeah, it's a stricter rule. It's a rule that is stricter. No, there's no doubt about that. That's why it's being proposed. And indeed, stricter still is Lord Justice Sullivan, whose views have become stricter over the years. His first report is at tab 33.
Is this pre-Jackson?
This is pre-Jackson, May 2008, as you see from the first page. But particularly, note that it is there, as it were, but then there's an updating report that he produced in August of this year, where he does consider the Jackson review. If you go into tab 34, if you would, you'll see the Jackson review in the second column on page 1119, bottom right-hand corner page numbers. See paragraph 21 in particular, referring to the qualified one-way cost shifting. And then the conclusions that are expressed is that, well, you'll see that they note, in the second column on 1120, you'll see that they note the proposal that I've just taken you to in Lord Justice Jackson's report. See paragraph 23. Do you see that? That's the passage, that's the test, as it were, that we've just looked at.
Yes.
And then you'll see that the punchline is that they don't agree with that and consider the matter should be phrased rather differently and perhaps even more strictly. See paragraph 30 on page 1121, i.e. the facing page.
You quote that in your further argument of paragraph 30.
Yeah. It's illustrative of the same point that there are live issues in a variety of ways in which one can achieve the purpose, but the core point from my point of view at this stage is that that is a change that would have to happen. And as we're making progress, question then is there anything that's occurred more recently that should lead to the conclusion, if I'm right up to this point, is there anything else that should lead to the conclusion that the cost officers should now be able to expand, and I'm coming closer, I think, to the point that my Lord Sir John Dyson was putting to me, we're getting to it ever by degrees, should now be able to, or should expand their jurisdiction to fill an Aarhus void, if there is one. And the focus, first of all, in relation to that submission, has got to be on the Aarhus Committee in the Port of Tyne case, which my Lords will no doubt have seen in the bundle.
Could we just identify it? I'm not sure.
My Lord, yes, it's at tab 31 in bundle 3. What you have there, rather confusingly, is a draft report, as you see on the first page. Can you flip forward and ignore that to the final report, which starts at page 935? (935) is the final report, the as-adopted report, rather than the draft one. And the relevant passages within that that start on page 964 and run through to page 966. So there's about 2.5 pages, of which there were 4 complaints, essentially, if I can summarise that little section. You don't need to bother about the one at the bottom of page 965 dealt with under 3, the bold title 3, challenging acts of private persons, because that doesn't concern us. They found under bold 4 at the very bottom of that page and over onto 966, they found that there was a problem in their view, under Aarhus, not merely with the cost regime, but also with the time limits regime under judicial review proceedings.
That's the 3 months time limit.
That's the 3 months
Yeah.
time limit, and they.
Yes, that was. Is that directed to the fact that even if you bring it within 3 months, courts have said you might still be out of time, which has always struck me as a bit of a false friend.
It seems to be the point.
That's exactly the nature of the concern.
Yeah.
Whereas my lords will recall,
yes.
and I think it's somewhere in these bundles, perhaps not referred to here, but that very point has gone to Strasbourg.
Oh, has it?
Yes.
To Strasbourg, to the European Court of Human Rights, and they've said, no, that's fine, that's consistent with Article 6. But anyway.
So they're looking for a clear...
Let's not get into a debate. I'm under specific instructions not to get into a debate with the findings of the Aarhus Committee, for reasons which will not escape my lords.
Yes. These have no legally binding, they're just...
My lord, that's the point I'm going to come to, but yes, my lord is right. You anticipate a submission.
Which are the crunch
I think I am allowed to
So
make.
is it paragraph 5 we're really coming to, Mr. Reading? Or
No, it's not.
No?
It's not paragraph 5. It is paragraph 2, going back, page 964
Right.
through to 965. It's really 128 to 136. They're the relevant paragraphs.
Yeah.
And I'm not going to read them out, but you will see that when you do read them, that in essence what is being said is that the system, the domestic current system, is not clear or transparent enough, and in effect needs to be codified. That probably needs to be referenced specifically to prohibitively expensive. I think they took a bit of objection to the fact that in one of the PCO cases it was said, well, it's a factor and no more. But those are the relevant paragraphs.
Yes, thank you. The main objection, as I understand paragraph 135, is the amount of discretion that's available. Is that a fair reading?
Yes. And
Without
the
any
fact-
clear legally binding direction.
Yes, I mean, you can imagine there was something of a debate before them as to whether or not one simply did focus on the discretion at the end of the trial process, as it were. I mean, there was quite a lively debate about PCOs and the various other mechanisms by which the court could operate, and there was also quite a lively debate about whether or not the mere fact that there was a discretion at the end of the day was a flaw rather than a virtue, allowing justice to be done in an individual case. And it was pointed out that there were, in fact, a succession of principles which governed the exercise of that discretion. It wasn't simply at large, but in any event, for good or ill, they've concluded that there is, in essence, a structural problem with the regime as it currently stands, and my lord is right. The key reasoning is in 135. Yes. My lords, can I make a couple of points in relation to this committee's report? First of all, my Lord Mance is right. This is not part of domestic law. See Morgan at bundle 2, tab 16, paragraph 22. Not going to turn it up, but it's there. But the committee have found what they found, and I'm going to come back to that in a moment. But you will need to note, when considering those, that there is now a process that is still to be gone through, even in the context of this body and this jurisdiction. And in particular, in that respect...
This is the body that's meeting next in June of 11.
Yes, and I'm going to go through the various stages very quickly in a moment, but the process is helpfully set out in a UN document at tab 30 of volume 3. Tab 30, volume 3, which sets out the basis on which this body operates and how it works, and the various bodies that sit above it. You'll see what it is purporting to do from page 891 behind tab 30, establishing the compliance committee and the structure and functions and so on. It is the policing body of the committee, but then you'll see also the various processes that are to be gone through, including in particular, could we invite you to just draw a line next door to paragraphs 35, 36 and 37 within this. So you will see that this is part of a process. There has been no response by the UK government to the final findings of the committee in advance of the parties meeting, or the meeting of the parties. The response to the draft findings was as set out in paragraph 25 of our response, the submissions before this court, which was that the government continued to consider that it complied with Article 9. However, be that as it may, the dialogue with the committee continues in relation to any proposed steps that the government is considering taking. That isn't, as you will have seen from the nature of the findings, in particular from 135 of the report, simply a formal process. There is potentially a great deal of discussion that might need to occur in terms of what would and would not satisfy by way of a revised structure for the domestic system. So that process hasn't completed or indeed to any great extent started, as I understand it. And when that process has reached an end, the committee will at that stage write a report to the meeting to be considered by the meeting of the parties. See paragraph 35 in the behind tab 30 that I've just invited you to draw a line next door to. And it will then be for the meeting of the parties, that is all the states in effect in plenary session, to make the final decision on what steps the UK does and doesn't need to take to deal with any continuing, if there are any after the discussions with the committee, to deal with any continuing issues of perceived non-compliance. You see that in paragraph 37 behind tab 30. And I should emphasise, in case I get taken aside at lunchtime, that the government, of course, respects and recognises the findings of this committee and are going actively and constructively to work with them to try to produce a solution which is acceptable to all concerned, including this committee.
If this things go the way they're going and continue to in June 2011, this would still be a non-binding, would it?
Yes, it would.
I mean, it's a United Nations exercise and there's no actual sanction.
Yes, it would. I'm going to come in a moment, if I may, to something rather more close to home.
Yes, which is the Commission
Exactly.
to the European Union.
Can I come to that in 1 second? Just a couple of points on findings. My Lord is right. The fundamental question, perhaps, to try to bring it back to the issues that actually arise in this reference to this court, is whether there is anything identified in the committee's report, even at the stage at which it currently sits within this UN process, whether there's anything identified that leads to the position that cost officers must have a discretion expanded to enable reasonableness to take in these sorts of overall reductions on the basis of prohibitively expensive, even assuming that to be domestically possible. And I've made submissions about that. And in my respectful submission, there is no such finding in the body of that committee report. The findings are fundamentally focused on, in essence, structural uncertainties, the need for clarity and so on. And those are structural changes that, if they need to be made, which it may be they do, if they need to be made, they would require new rules. They would require changes to the current rules. And that is precisely why there are all these various reports suggesting formulations. Lord Justice Sullivan, Lord Justice Jackson and so on, both of whom had a serious and weather eye on the Aarhus Convention. Can I just pick up one point? You will have seen in paragraph 131 of the final report, or you will do when you have a chance to read it rather more carefully. You'll see what paragraph 131 says. It's behind tab 31 on page 964.
Yes.
But that appears, really it's just an invitation to right next door to paragraph 164, please do go to the relevant part of the Sullivan report, which is footnoted, because that paragraph taken in isolation could perhaps be taken as suggesting something rather, or perhaps considerably even broader than it is in fact dealing with. If one goes to the relevant paragraph in Appendix 3 to the Sullivan report, you will see it's dealing with something very narrow. That is in, that reference is in tab 33, page 1102, is paragraph 14 of Appendix 3 to the Sullivan report. Tab 33, 1102 is the page number, paragraph 14 is the footnoted reference.
Yes.
It's perhaps also worth drawing your attention to paragraph 134 in the committee's findings, which deals with the public interest nature of environmental claims, and in relation to that we say that that is something of which the courts already are fully aware, the potential public interest nature of these sorts of cases. It's not entirely clear if I can stray at least this far towards at least raising a question about some of this report. It's not entirely clear on what basis that particular paragraph was found, but in any event, the courts are well aware of the importance of these sorts of cases and take it into account to be balanced against other considerations in determining questions, for example, about PCOs. So that is Aarhus. Yes, my learned friend reminds me it's right to make this point. I'm going to come back to it anyway, but nothing in that report deals with subjective, objective.
No. Yes, thank you. No, we're practically at 1 o'clock.
We're practically at 1 o'clock. I'm going to be no more, I think, than 25 minutes after lunch. I'm going to deal with the Commission position, and I've got to deal with objective, subjective. But that's, for all the importance, potential importance of it, that's a relatively short set of submissions. And I'm assuming that the court will have had at least an opportunity to see the Ghana decision, the Court of Appeal decision, which deals with that directly, but I'll take you and show you the relevant paragraphs.
Yes.
So 25 minutes, I think.
Mr. Wolfe, how about timing for you?
My Lords, obviously I can take things relatively quicker because you have been taking through many of the materials, but I expect to need it around an hour.
Yes. Well, we'll sit again at 2, and there may be a little flexibility around 4 o'clock, although we'll try to finish then if we possibly can.
Very grateful.
Thank you very much.